Welcome to Understanding Mortgage Forbearance, the Eviction Moratorium, and how owners can work with tenants throughout this process. This is a webinar that we here at Nixon Peabody are putting on to go through this very important topic. And joining me, my name is Richard Price. I'm a partner at Nixon Peabody's Washington, D.C. office, and joining me is Brian Donnelly, who is counsel with Nixon Peabody in our New York City office, our Washington, D.C. office. I just moved you, Brian, just for the heck of it. And also in our Washington, D.C. office is Harry Kelly. And Harry and I have practiced together way too long. But we've had a few of these sorts of webinars, and we just decided that it was time to have it again. So basically, today we're going to cover a few topics regarding eviction moratoriums. But first, let's cover a few logistical instructions. Today's call is being recorded. A copy of the recording will be shared by Nixon Peabody in the next few days. To see all of our panelists, we recommend using the grid view in WebEx, which you'll find in the upper right-hand corner of your viewing screen. You may send questions to our presenters online. On the bottom of your screen, you will see a Q&A box. Please type your questions into this box and submit them to the presenters. We'll do our best to answer your questions during the webinar, or we'll follow up after. And just so you know, some folks have already submitted questions. We do have those. As you might guess, some of those questions overlap or are in parallel because inquiry minds want to know the same kinds of things. So we do intend to cover those topics through this webinar as we proceed. Now, for those seeking continuing education credits, please take note that I will announce an attendance verification code during the presentation. Please write down the code as you will need it to provide the code on the certificate of attendance form, and you'll need to complete that form and return your certificate of attendance and the evaluation form to Nixon Peabody. Upon receipt of your certificate of attendance verification form, you will be issued a certificate of completion. All certificates of completion will be emailed within 45 days after the webinar. Of course, if you are experiencing technical difficulties during the webinar, please also use the Q&A box to alert us, because we want to make sure everyone can hear everything. So I'm going to kick off, and I'm going to attempt to move this forward. And here we go. So today we will cover this agenda. We'll discuss the eviction moratorium, mortgage forbearance, and how owners can work with tenants throughout the process. We're going to focus on a few items in particular: the recent CDC order and former CARES Act moratorium, state and local moratoria, the CARES Act mortgage forbearance, current HUD, Fannie, and Freddie policies, possible federal assistance that might still be available, and negotiating with tenants under current circumstances. So those are our bright, shiny faces with much more polished views in the office there. So federal moratorium, CDC order. Let me start off by talking a little bit about this, and then we'll turn it over to my colleagues. So the thing that's, I think, driving people's questions today and trying to figure out what to do on a federal level, on a national level, and indeed encapsulating, the series of activities, a series of state and local laws, a series of concerns, is the recently issued CDC order. So this was issued by the Centers for Disease Control and Prevention, CDC, not typically a housing agency. It was issued on the web September 1st, went into effect September 4th. And what it basically does is it attempts to prohibit, under certain circumstances, eviction for non-payment of rent in order to help prevent the further spread of COVID-19. Now, as a housing lawyer, I have a few questions about the legality of this order, but we're going to focus first and foremost on what it is, how to comply with it, how to deal with it, because it is there. First of all, the authority for this order is under Section 361 of the Public Health Service Act. And what that provides is the CDC may make and enforce certain regulations to prevent introduction, transmission, et cetera, of communicable diseases. Interestingly, this law is been used in the past, some case law for things like seizing tainted milk or quarantining an individual with a particular disease. This use is new. And what's key about this statute is the statute triggers the rulemaking authority of the CDC, not, I would submit to you, something that is in effect in and of itself. So the CDC has to pass a rule. So what rule are they operating under? They're operating under 42 U.S.C. 70.2, and that rule says that the CDC director can take such measures as they deem necessary, and they determine that the measures taken by state and local authorities, basically, are insufficient to prevent the spread of communicable diseases. Now, that's the notion there. I will just kind of take a second about a sidebar. A couple of thoughts that occur to me is that this order does not seek to prohibit or inhibit ingress or egress of any units or particular units, and does not interfere with the movement of individual tenants or groups of residents. At the same time, it does not basically attempt to limit eviction for anything other than non-payment of rent. So on the one hand, it would seem that I'm sort of arguing it should be even more expansive. On the other hand, I'm not. What I'm saying there is that it's not narrowly tailored or reasonably tailored, I would suggest, to its purpose. And we're going to talk a little bit as we go forward. I'm going to cover some current cases that have been filed seeking to overturn the order. But until that happens, the order is there. But that's been sort of my biggest concern. The other issue with this order is that even as we raise concerns about the federal government's role and the CDC's role, there is still the ability that is more broadly recognized for states and localities to be able to take these kinds of actions. So it's the sort of thing that it is an issue whether or not the CDC's order is in place. It's still an issue. So the nature of the order, it's an order, not a rule. So we don't go through the Administrative Procedures Act, notice and comment rulemaking. It's already in effect. And it's for the public purpose of preventing and addressing the historic threat to public health. How it works. And here's really the meat and potatoes on this, because until something else changes, this is in effect. The first thing you have to realize is that if you have a state or local law that's more restrictive, that still is in effect, that still governs. State or local law, state or local order. So in this particular order, assuming there isn't a more restrictive state or local requirement, this order restricts eviction of any covered purpose, any covered person, from any residential property. It does not relieve the residents, the tenants' obligation to pay rent, does not prohibit fees, penalties, or interest. Now, this gets a little confusing, and we'll talk about the CARES Act as we go forward. That CARES Act has some different provisions, some of which are no longer in effect technically, but they're sort of in effect aspirationally, and others are still in effect. So it gets a little confusing on the federal level, but this order, which really has the most overarching effect, it does not prohibit fees and penalties or interest on payment of rent, does not prohibit evictions for reasons other than non-payment of rent. How broad can we take that, evictions for other reasons? Well, there are a couple of examples, but at the very least, we're talking about violations of contract, violations of public safety, and so forth. So let's first talk about, very quickly, the protection. Now it applies to tenants, lessees, residents. A covered person is someone who submits a declaration under penalty of perjury that contains specific information about income, cause of inability to pay rent, and the likely effective eviction. It does not require the declarant to provide supporting documentation. Eviction means any action for possession. Restriction applies to any party that has legal right to pursue eviction or possessory action. So there have been a number of questions. Does this apply to me? What if what if I have a sublease? What if I lease a block of units and then I lease those out to individual residents, people with special needs populations, and so forth? And the short answer is that this order is written very broadly. So if you have a right to evict, an authority to evict, you could move to evict somebody, regardless of what your role really is and exactly what your title is. But if you have that right, then this covers you. This covers whether or not you can move forward with the eviction. Similarly, this covers not just people on the lease, but also residents in a unit. There are criminal penalties for violation. If you move to evict somebody and you it's found out to be a violation of the order, then you're subject to fines and other penalties. And this is, these get to be very hefty. Individuals can be subject to a $100,000 fine, and that can go all the way up to $500,000 under certain conditions. I'll let Brian cover that in a minute. Other penalties, if you are filling out the form, if you're the tenant filling out the form, you're filling that form out, the declaration out under penalty of perjury, and a false declaration is also subject to civil and criminal fines. Again, the CDC order exempts any state, local, or territorial or tribal area with more restrictive, more protective eviction moratoria, which is interesting because the statute itself says that it is not empowered where there is a greater restriction from a state or local government. So this is just a sort of a natural part of that statutory construct. The order does exempt American Samoa, which is an interesting sidebar because apparently they've had no COVID cases according to the order. And you can have, in that greater restriction, you can have greater restrictions. That is, you can have state or local governments, bar eviction for other reasons as well. I'm going to pause there and we're going to go through the form declaration. I want to pick that one up.
Sure, I'll pick it up. Thanks, Richard. So I'm going to talk about the major legal challenge to the order in a moment. But before I do that, I want to go through what's required by this declaration, because that's really what triggers the landlord's prohibition from eviction. And there's a form of declaration provided by the CDC. The form provides that it must be completed by each adult listed on the lease, rental agreement, or housing contract. So it's not the case that one per unit is sufficient. By the plain terms of the declaration itself, anyone whose name appears on the lease or rental agreement needs to submit a declaration. So what is the declaring essentially? So they're certifying a number of things. One, they've used their best efforts to obtain all available government assistance for rent or housing. Two, they meet certain income restrictions, so they earn no more than $99,000 an annual income for CY 2020, or if they're filing a joint tax return no more than $198,000, or they were not required to report any income in 2019, or they've received an economic impact payment, stimulus check pursuant to the CARES Act. They need to certify that they cannot pay full rent due to substantial loss of income or extraordinary out-of-pocket medical expenses. And what's significant about that is it's not explicitly limited to COVID-related causes. So this is, broader than just inability to pay due to COVID. And Harry's going to touch on that in a few moments. A few other certifications. They need to certify they're using their best efforts to make timely partial payments. So if they can pay part of the rent, they're supposed to be doing that. They need to certify they would likely become homeless or move into a shelter or shared residence in which they would live in close quarters with others if they were to be evicted. And this ties back to the purported purpose for the rule or the order, which is to prevent the spread of communicable diseases. It's a tough word. A couple more, they need to acknowledge that they do still have an obligation to pay rent and fees and penalties and to comply with other contractual obligations. And they need to acknowledge that the moratorium is due to end December 31st, 2020. And after that time, they may be required to pay the rent in full or face eviction. Now, the form's available at the link we put there. I'm holding a copy in my hands. Obviously, if a tenant prints this out and signs it and hands it to a landlord, that's an effective declaration, which should be treated as such. But I don't think there's any magic to this form itself. I think if a tenant were to, write their own declaration that includes all the necessary certifications and signs under penalty of perjury, that should be treated as an effective declaration. So moving on to the fun stuff. So I'm a litigator by trade, so this is the stuff that gets interesting for me. Invariably, at least every lawyer I've spoken with's reaction to CDC eviction moratorium is, wait a second, that's Centers for Disease Control, right? Yes. Can they do that? And the answer is we're probably going to find out. So the New Civil Liberties Alliance almost immediately filed a lawsuit after the order was handed down in the district court in Georgia, and that's where the CDC is based. Of course, in any test case like this, the name of the game is finding the best plaintiff. I think they found a pretty good one in this case. So this was brought nominally by an individual, Mr. Brown, who's the owner of just a single-family residence in Virginia, not a big apartment complex. It's a house that he owns. He owes a mortgage on it, and he leases it to a tenant. And I think the tenant owes him something like $8,000 in back rent. And of course, under the terms of the order, he can't pursue eviction. Practically speaking, he's never going to see that money, and he's essentially, tied to those damages. 3 other individual plaintiffs joined the case after it was filed. Similarly situated individuals, one in North Carolina, one in South Carolina, and one in Georgia. And again, these are all owners of single-family residences that they're leasing to tenants, and the tenants aren't paying rent. And then the case was eventually joined as well by the National Apartment Association, which is a trade organization of owners and landlords of rental properties. It's kind of interesting to look at the lawsuit in terms of how the CDC order relates to the various state rules that are in play here. So in Virginia, there was a Supreme Court order that suspended writs of eviction through September 7th. So of course that date's significant because the CDC order was handed down right around that date. So in Mr. Brown's case, he was ready to evict his tenant for non-payment. CDC order comes down, and now he's prevented from doing so. In North Carolina, there was an order preventing evictions for non-payment through July 20th. And in the case of the North Carolina plaintiff, they actually have a writ of eviction that they now can't execute because of the CDC order. Similar situation in South Carolina. This plaintiff has a writ of eviction. They were ready to go. There was an eviction stay through May. In South Carolina, that expired. CDC order comes down. Now they can't execute their writ. Georgia, which had no restrictions, plaintiff has a property in Georgia. They filed an eviction proceeding. Everything was moving along. CDC order comes down and that proceeding is stayed through January of 2021. So it's we'll talk about the various state rules and state laws in a few moments, but it's interesting in this case to see how the CDC order plays against all of this. So, what is the case alleging? So the case alleges the CDC order, violates the Administrative Procedure Act, the APA, in a couple of different respects. And it also throws just a kitchen sink of constitutional arguments at it. So what are some of those arguments? APA, two main arguments. One, this is unauthorized agency action. So in the Administrative Procedure Act, an agency such as the CDC can only take actions it's authorized to do. Now, in this case, the agency does have broad authority to prevent the spread of communicable diseases from state to state. But what the plaintiffs are arguing here is there are specific means that they're allowed to use by statute. So they can inspect, they can fumigate, they can disinfect, they can exterminate and destroy animals. What's not included in that list is evicting or moratorium on residential evictions. So the argument is they have no authority to do that, and this rule therefore violates the APA. They've also made a claim that this is an arbitrary and capricious agency action, and Richard touched on some of those reasons earlier. It's significant. There's no findings in the order itself that any particular state was taking any action that was insufficient. There's no finding that an eviction moratorium is the only or the best way to prevent the spread of COVID-19. So there's a lot of good arbitrary and capricious arguments that have been levied against the order in this case. Some of the constitutional arguments, you'll see these pop up in a DC case later on as well. Under numerous provisions of the Constitution, individuals have a right of access to the courts. So alleging, obviously, folks can't pursue eviction proceedings in the courts. And in this case, that's the individual plaintiff's only means to mitigate their damages is to go to the court and, seek a writ of ejectment to get tenants out of their property. They have no other means to, retake possession of their property or recover the money that, practically speaking, they're never going to get back. Supremacy Clause. So, laws of the United States and Supreme Law of the Land. The argument there is, well, in order for that to be the case, an agency needs authority to pass the law. And it's similar to the APA argument. There was no valid authority for the CDC order here. 10th Amendment. So this is the provision of the Bill of Rights that says any powers not delegated to the federal government are expressly reserved to the states. There's a couple of different ways that comes into play here. One, the argument is, landlord-tenant contract law is really a province of the states that the CDC is invading here. The second prong of that is, it's interesting, it's the CDC is really commandeering state resources to enforce federal law, which is also a constitutional violation. So they're asking state courts, state law enforcement officials to enact and enforce this federal policy. And then finally, a separation of powers argument. So the argument there is this is really legislative action taken by a branch of the executive government, which violates the constitutional separation of powers. So, what will the effect of this case be? There is a potential for a nationwide injunction here. They've asked the court to invalidate the CDC order. Last week, they filed a motion for a preliminary injunction, and briefing on that is scheduled to be complete October 16th. So I expect sometime after that date, there'll be some kind of decision on the preliminary relief the plaintiffs are requesting. Which way that'll go, it's hard to say. That the judge that's been assigned to the case is a recent Trump appointee, though he was confirmed by a relatively wide margin by the Senate. So it's really hard to read the tea leaves as far as which way he might decide on this one. But for now, the bottom line is, will this might change in the future? Maybe. For the moment, the CDC order does remain in effect, and folks need to know what they need to do to comply with it. So with that, I'm going to send it over to Harry, and he's going to talk about some frequently asked questions that have arisen under the CDC order.
Thanks very much, Brian. Appreciate it. And good afternoon to everybody who's on the call. one of the things that happened very quickly after the CDC order took effect was that we began to get a number of questions from clients and other people asking how does this work out, and some of the fact scenarios were very interesting and provocative. They tended to organize around a couple of major themes, and so we're going to try to address those for a few minutes this afternoon, beginning with one question which seems pretty obvious when you stop to think about it. First question is the CDC moratorium limited to non-payment of rent for COVID-related reasons? And as Richard has discussed, talking about the terms of the declaration that the tenants have to file, there is no question that says, I have financial problems because of COVID-19 or related to COVID-19. The questions that tenants are asked don't directly deal with that topic. And so there is no requirement to tie the inability to pay rent or the likelihood of homelessness directly to COVID-related causes. It's conceivable that somebody has lost their job for reasons unrelated to COVID or has other financial problems unrelated to COVID. And they don't have to tie their financial distress in any way to the virus. And that's important because many landlords or managers may say, well, what I know about this tenant is the extent that they're not paying their rent. They're not paying their rent for reasons unrelated to the virus. And the answer is, it doesn't really matter. I don't know whether that was an intentional omission or just a mistake in drafting the declaration, but at least for the moment, the declarations do not require a tenant to indicate that they can't pay their rent because of some COVID-related reason. What if a tenant or resident does not satisfy all criteria in the form declaration? Obviously, again, as Richard discussed a few minutes ago, there are a number of different certifications that people have to make, and depending on how thoughtful they are or whether they're operating in good faith, some people may say, well, I can say yes to 5 of them, but not to all of them, or there are a couple that they may feel uncomfortable about answering. Well, the answer is that in order to have an effective declaration, you must in fact satisfy all the criteria that are set forth in the declaration, and do so, as Richard said, under penalty of perjury. So again, a partial declaration is not really effective. What if a tenant or resident has violated other lease provisions in addition to failing to pay the rent? Under the guidance from the CDC order, a tenant may be evicted for other quote unquote for cause reasons. The order itself contains a list of those, and they involve things like criminal conduct, violence towards other tenants, other grounds that may allow for eviction of a tenant. And there's a catch-all at the end that says other violating other contractual obligations. So for all of those grounds, the CDC order says a landlord may proceed and may evict. Our recommendation is that if you have grounds that are both related to non-payment of rent and other for-cause reasons for eviction, that you, if you're going to proceed with an eviction notice, do it by specifying the for-cause grounds that are not related to non-payment, because that's the safest and clearest avenue towards moving forward for eviction. If your eviction notice says this tenant has committed violent crimes against other residents and has not paid their rent, a court may say, well, if they haven't paid their rent, then we're not going to allow you to proceed with eviction to the extent that you're claiming non-payment is one of those grounds. So better to proceed with a clean eviction notice than one that makes an allegation of non-payment. What about a tenant or resident whose lease is expired? Well, it depends on the terms of the lease and what the state or local law says. There are a number of jurisdictions and many leases that have been developed over time and that treat a holdover tenant not as a trespasser, but as simply as a month-to-month tenant, or make some other kind of arrangement so that it's essentially permissible for the tenant to remain. It is not for purposes of the CDC order, a violation of some other contractual obligation. And so you need to take a look at the lease and see what the lease says. If holding over is in fact a lease violation, then likely the eviction wouldn't be prohibited. But if the lease makes arrangements or accommodations for a holdover tenant in the four corners of the lease, or state or local law has something to say about it, then you need to be cautious in taking any further proceeding. It might not amount to a violation and therefore might be outside the scope of what the CDC allows. This is certainly an area where you need to speak to your local council to make sure that they are you get sound advice on what both the lease and the state and local law say. Well, what happens if a tenant doesn't submit a declaration? We don't know too much about it yet, but it appears that that if a tenant or resident may be evicted for non-payment of rent if the tenant does not provide a declaration that contains the information required by the CDC order. The order says that for a tenant to, quote, invoke the CDC moratorium, that's the language that the CDC order uses. For a tenant to invoke moratorium, they have to present a declaration. It almost seems to create a situation where, well, why would a tenant give you a declaration? Would a tenant simply do so because they're out of cash and they don't have the money to pay the rent and come to the landlord initially with a declaration without any further contact from the landlord? Or more likely, would the tenant receive a notice of non-payment or a notice of eviction, and then at that point trigger the CDC moratorium by handing the landlord the declaration? So it seems that at a minimum, until the time that the tenant actually presents a declaration, they haven't properly invoked the CDC order's protections. The question is, what should the landlord be doing proactively to put themselves in the best position? We feel that a landlord, before subjecting themselves to the kind of risks that we discussed before about criminal and civil penalties, and also in order to make the process go as smoothly as it can under the limited avenues that are available in the four corners of the CDC order, the landlord should do some kind of due diligence before initiating eviction proceedings. And by that we mean, at a minimum, if a tenant has not paid the rent and the landlord is thinking about initiating eviction proceedings, to do some kind of contact with the tenant to find out what their circumstances are. Are they really in a situation where financial stress has prevented them from being able to pay the rent? And if the landlord concludes through that process that the tenant meets the criteria of the declaration, the least risky course, at least at this point, is not to pursue eviction. The guidance from the CDC is very clear that the tenant still owes the rent, and it is still, at least conceivably, subject to collection at the end of the eviction term, the end of the moratorium. So in a lot of respects, the least risky thing to do is if the tenant becomes, if the landlord becomes aware that the tenant can't pay the rent, to forego the case. If the landlord concludes the tenant doesn't meet the criteria, if they're able to do some advanced due diligence and conclude the tenant can't meet the criteria, there is what we call a rebuttable presumption that the landlord can pursue eviction, because if the landlord feels that the tenant is not going to present them with a declaration, then the CDC order seems to say that the eviction can proceed. Again, why? Again, because only when the tenant invokes the CDC order by presenting the declaration does the process stop. However, it's very clear under the CDC order that a landlord must stop the eviction proceedings immediately if a tenant or resident submits a declaration of the kind that we described earlier. Can a landlord challenge the accuracy of a declaration submitted by a tenant or resident? Well, again, this declaration is signed under penalty of perjury. that's a serious thing. At least for lawyers, we know that when we ask somebody to sign a declaration, we always make sure that the facts are carefully reviewed with the declarant. The declarant understands what they're signing and signs the statement with full knowledge that they are doing so pursuant to a potential perjury charge. And so we're very careful whenever we draft a declaration for that reason. This declaration has a lot of provisions to it. For many tenants, they may feel uncomfortable signing a declaration, given the possibility that they don't really know what the declaration, all the terms of the declaration mean, or that they're absolutely sure that everything the declaration requires them to state are things that are factually true. But nevertheless, if a tenant does sign the declaration, it is signed under penalty of perjury, and the tenants are not required to produce any other documentation to support the claim. If the landlord has evidence that a tenant can pay the rent based on the due diligence that we talked about before, or otherwise doesn't meet the requirements of what the declaration requires, it may be able to show that the declaration is fraudulent or somehow otherwise invalid. Again, to our knowledge, these cases have not been litigated yet, and to what extent the landlord can use a fraudulent statement, a declaration, to proceed with an eviction, or even to have a separate cause of action against a tenant. These are still matters that have to be further evaluated, and whether they get decided or not by the end of the moratorium is a good question. Can a landlord insist on partial payment? No. If a tenant qualifies for a declaration, the landlord has to accept that declaration and can't require the tenant to make full or partial payments on the interim. However, in situations like this, where there is evidence that a tenant is not going to pay their rent and is presented a declaration, we do believe that it's appropriate for the landlord to try to reach out to the tenant and explain that the tenant still owes the rent, and therefore what would be beneficial is to have some form of a repayment agreement or a rent forbearance agreement, whatever you want to call it, that lays out the amount that's owed. It makes clear that the landlord does have a right to receive those funds eventually, and includes provisions with respect to what happens when the moratorium expires, and the landlord, and verifies the landlord's ability to proceed with evictions whenever the moratorium is expired. I'm sorry. Let's assume for a moment that a tenant has violated the lease obligations other than non-payment of rent. When the landlord delivers a notice of eviction, the tenant serves a declaration on the landlord. That's the process that we talked about before. Is the landlord prevented from moving forward with eviction? As we said, the process seems to be that the order requires the tenant to formally invoke the moratorium, and therefore says that until that time happens, the landlord has a right to proceed with the eviction. But the CDC order also says that a covered person who delivers a declaration may still be evicted for reasons other than not paying rent or making a housing payment. So apparently, even after the tenant does deliver a declaration, if there are other for-cause reasons to proceed with eviction, the CDC order seems to suggest that the landlord may proceed with a for-cause eviction, irrespective of having received that declaration. But again, you've got to be sure that if you are proceeding with the eviction, it's very clear that it's being done on the basis of causes other than the non-payment of rent. So let's turn to a couple of other historical matters and take a minute to think about how the law has changed over time. One of those matters is the fact that back when the CARES Act was originally adopted, it included a 120-day moratorium as well. This was really sort of the granddaddy for all the moratoriums, moratoria that are in place now. That 120-day eviction moratorium expired late in July of 2020 and allowed owners to proceed with evictions after 30 days notice, which basically meant the end of August, which also was right around the same time as the CDC moratorium took effect. It had a different scope. It applied to a wide range of federal programs, including the low-income housing tax credit programs, Section 8 rental or assisted properties, properties insured by the Federal Home Administration, and properties subject to Fannie Mae, Freddie mortgages, RD properties, and so forth. It prevented evictions, but some of the provisions of the CARES Act moratorium are different from the terms of the CDC moratorium, and people should be aware of the similarities and the dissimilarities. For example, this current moratorium prohibits evictions. The CARES Act moratorium prohibited even giving a notice or filing an eviction process for non-payment of rent. So again, that's why we say that it seems as though the current CDC order would allow, in most cases, filing of a notice of eviction. The old CARES Act moratorium did not allow that. It prohibited assessment of penalties and fees for non-payment during the pendency of the moratorium. It applied to tenants with or without leases, and it prevented evictions in process when the moratorium began. So those are some of the differences between the CARES Act moratorium and the current CDC moratorium. But like the CDC moratorium, the CARES Act moratorium did not prevent evictions for reasons other than non-payment of rent. We discussed extensively the idea of for-cause evictions. Nor did it relieve tenants of their obligation to pay the rent. Both the original CARES Act moratorium and the new CDC moratorium all envision that tenants will remain liable for unpaid rent going forward. And just to complete the big Venn diagram of all the moratorium that are in place here, there are a couple of others that you should be aware of. The Federal Housing Administration still has a moratorium in place that prevents the initiation or execution of evictions from properties that are secured by FHA-insured single-family mortgages. Note that single-family mortgages. And that protection is extended through December 31st of this year. Similarly, Fannie Mae and Freddie Mac also have prevented evictions from single-family properties with Fannie or Freddie-backed mortgages through at least December 31st. And there are, to the extent that owners are subject to or have taken advantage of loan forbearance for multifamily properties, no evictions from those properties are allowed during the duration of the forbearance period. And I think at this point I turn the mic back to Brian. Thanks.
Thanks, Harry. So I'm going to turn to the various state and local moratoria, which are not necessarily preempted by the CDC order. Again, the CDC order says it applies to states and local jurisdictions whose protections are not equal or greater to the protections of the CDC order. So it's still important to look at your state and locality specific law and study any of those protections as well. So currently there's at least limited protections in place in 20 states, including DC. And they vary pretty widely, including, by how they're enacted. So some are executive measures, some are legislative measures, some are even judicial measures taken by the courts. They generally fall within 4 categories. So some states prohibit even the commencement of eviction proceedings, meaning you can't file for an eviction in court. Some allow you to file, but then it'll automatically stay the eviction proceeding until a specified period of time or after the emergency is declared ended. Some allow you to file and proceed with an eviction proceeding, but basically provide the tenant an affirmative defense based on COVID-related hardship or failure to pay or something similar. So the tenant would still have to go to court and provide some evidence of qualification for the moratorium. And then some will let you get a writ of ejectment or an eviction order. You're just not allowed to enforce it. So it's kind of the basic breakdown of how the various states approach the problem. And it's also important to note that the duration of these protections and moratoria also varies by state. So they're all scheduled to expire at various times. So again, it's really important to consult with local counsel and really study the particular law where your property is before proceeding under state or local law. Now, how will the CDC moratorium affect the extension of state and local moratoria? It's hard to say. Again, the CDC moratorium carves out applicability to states who have equal or greater protection. What that means, CDC hasn't really expanded on that. But obviously, if you live in a state whose moratorium is self-evidently broader or stricter than the CDC order, you should certainly follow anything that goes beyond the CDC order. So I'm going to go through just a few quick examples of how some states are handling their moratoria. New York, for example, the Tenant Safe Harbor Act prohibits residential evictions during the span of the COVID emergency. That is one of those statutes that requires, it basically provides an affirmative defense. So a tenant would have to go to court and demonstrate that they qualify. However, the New York courts then issued their own memorandum saying, we're not going to hold eviction proceedings until at least October 1st. So that's by judicial order. There's no eviction proceedings in New York, residential eviction proceedings until at least October 1st. The New York Office of Court Administration has said that the court is not going to or not likely to extend that, which doesn't necessarily mean the moratorium is going to end on that date. It just means that action would likely have to be taken by the legislature or the governor for that residential moratorium to continue past October 1st. And with respect to commercial evictions, the governor's executive order extended protection for commercial evictions. It was to expire September 20th. That's since recently been extended to October 20th. California, there's been a lot of action recently in California. Recent legislation prohibits evictions before February 21st, 2021, but it gets a little bit complicated. So it applies to complete non-payment of rent accrued between March 4th and October 31st, 2020 as a result of a COVID-19 hardship. So if a tenant had a hardship and could not pay rent at all during those dates, then they may not be evicted before February 1st. For non-payment of rent between September 1st and January 31st, tenants would still have to pay at least 25% of their rent during that period. If they do pay at least 25% of the rent, then again, they can't be evicted before February 1st, 2021. To qualify for the protection, tenants in California need to provide a declaration of hardship. And with respect to commercial evictions, the governor just signed an order recently that allows local jurisdictions to ban commercial evictions through March 2021. So this is not a statewide ban on commercial evictions. This leaves it up to the localities to do so, and they can do so through March 2021. So again, really important to look at your local law to see what apply. And finally, the District of Columbia. So this is one of the stricter regimes, at least that I've seen. So, and it was just a couple of days ago, I think, got even more strict, and I'll talk about that in a moment. So no evictions during the emergency period, which currently runs through October 9th by order of the mayor. Any existing eviction proceedings were stayed, so they're just sitting in the courts going nowhere. What's significant about DC is they've said there can be no new eviction proceedings filed until 60 days after the emergency period ends. So at this point, that's sometime in December, although the City Council just authorized the mayor to extend the emergency period, which in turn would extend the prevention on new filings for another 60 days. So we'll see what the mayor does in response to that. So that latter protection against new eviction filings is called the Filing Moratorium. It's currently being reviewed by the DC Superior Court for a number of constitutional reasons, very similar to those raised against the CDC order. So, unconstitutional taking of property without compensation, deprivation of access to the courts, and some other arguments. So the courts decided they're going to take a look at those common questions of law. Briefing on those cases is set to be completed by November 20th. So you're not going to see a decision on the legality of that filing moratorium until at least late November. One other point on DC, so, and I saw a question in the comments earlier, can I issue a notice of eviction effective January 1st when the CDC order is scheduled to expire? In DC, now you can't. So the DC Council just a couple days ago passed an emergency resolution that prohibits even giving a notice to vacate to a tenant. So whereas before you couldn't go into court and file an eviction proceeding, you weren't necessarily prevented from providing a notice to vacate. The City Council has just recently said no, landlords can't do that either. What's also significant about DC, two things. One, the moratorium applies to all evictions, so this is not just inability to pay rent. Tenants simply can't be evicted. And it also applies to both residential and commercial evictions. So it's a very broad moratorium in DC. And with that, I'm going to send it back to Richard to talk about our next major topic, which is mortgage forbearance.
Thank you. And I'm going to attempt to advance this slide. There we go. So we're talking about eviction moratoria, and now we're going to talk about mortgage forbearance. And the two, of course, are related. They're related on a few different levels. Most prominently is the CARES Act that was passed back in March, which had two eviction moratoria, one that ran from March 27th, I forget that date, to July 24th, and that's essentially expired. And that is, 4023. I think it still has vitality as sort of an aspirational provision. HUD has issued FAQs and Fannie and Freddie have issued guidance to the effect that landlords should do what they can to work with residents. It's part of the public policy mission. And if I can sort of say it, if you have a good tenant, you have someone that you've worked with, you have, I will say that I'm currently sitting in an apartment I rent, so it's, as a tenant, I like to think I'm a good one, but it's, you as a landlord, you want to keep, those folks, and we have a number of folks hitting an economic rough patch. So if there's an opportunity to work things out, that's strongly encouraged by these agencies. And indeed, Fannie and Freddie, FHFA, Federal Housing Finance Agency, has issued guidance to the effect that if there is a further extension of the mortgage forbearance for Fannie Freddie, that essentially you have to advise the resident of that fact, and in essence extend benefits. There are certain places like District of Columbia, DC, that has passed a local law that has required lenders to extend a forbearance, and that upon issuance of the forbearance, the landlord has to extend that equivalent benefit on to the residents. And that, after all, is the point of a lot of this mortgage forbearance. The policy makers in the country are interested in helping property owners, but they're more interested in helping the customers of property owners, and that also helps out not only the property owner by having their customers taken care of, but also obviously protects the people at the bottom of that particular economic chain, and in fact the source of all of the, not only purpose, but all the revenue that is why we provide housing in the first place. So there's a lot of that sort of aspirational push behind it, and at some point it becomes some measure, legally speaking, contractual, or perhaps regulatory guidance, not really regulations, but a form of guidance as well. Contractual in that these are terms that places are being appended to for mortgage forbearance requirements. So all are important. Let's see, I'll just advance that slide one more time. And it will eventually, there we go. So I'm going to skip over 4023 and I'm going to get to a couple of other things, 4024. So I'll stick with this slide here with Fannie and Freddie. So Fannie and Freddie basically, as I said before, requiring owners to suspend evictions for non-payment of rent during the forbearance period. In that additional tenant protections are required for new or extended forbearance as of June 6th. Those requirements include providing a 30-day notice to vacate, not charging late fees and penalties, and so forth. Essentially, the Fannie-Freddie type guidance came out just before the CARES Act, was augmented by the CARES Act, and has continued with a kind of almost sort of a parallel vitality. The CARES Act also sorry for jumping around the slides, the CARES Act also provides for a additional provision, which is in 4024, which basically provides that if you if you have an FHA loan, a Fannie loan, a Freddie loan, and you obtain a 90-day forbearance, arguably 3 30-day forbearance periods, but 90 days, then you do have to, by law, pass that benefit on to residents. And that's a different eviction moratorium than the original eviction moratorium that ran when the CARES Act started. So there's one that protects residents when the CARES Act started, which expired at the end of July. And then there's a second that goes in parallel, that tracks along the mortgage forbearance. And that mortgage forbearance period, in many instances, the initial time period has run, but in other places, either lenders have extended that forbearance, as I was talking about a moment ago, or the borrower didn't go right in for the forbearance and it was done at a later date. Essentially, those forbearance authorities run through the end of the year, or should the president declare the emergency before then, but that obviously doesn't seem likely at this point. So basically, and I think one key thing as a compare and contrast between the CDC order and the CARES Act forbearance / eviction moratorium is that under the CARES Act, you cannot charge late fees, penalties, non-payment of rent, whereas under the CDC order, you can. So even among the federal law, it really becomes really important as to what you sign, as to what money you've accepted, what you've agreed to as a landlord, as a property owner, as well as by as a tenant as well. And one thing to circle back on is, what other resources are there for landlords, for property owners who are looking to work with their residents, keep things up and running, and what other resources are there for residents that very much want to pay their rent, that don't want to have this sort of weight laying on them of having to, maybe get a temporary benefit now, but afterwards have to face a sort of wave of financial obligation. And the CARES Act provided some assistance, but that assistance, while very much appreciated, was largely for units on the multifamily side, certainly for units that were already subsidized. There was some additional money granted block granted out, essentially under the what's called the ESG-CV and the CDBG-CD programs. The links to those are on this slide here, and you can also Google those two programs. The CDC order expanded the authority to allow, to the extent there was any doubt, to allow those funds to also be used to assist residents with payments. I will say some of the waivers that were provided for those programs also go into other things, also very needed. Administrative costs, some what I'll call capacity buildings, not exactly the right term, but it's hard to stand up an army unless you've paid and you've created the infrastructure for that, and you basically need an army of sorts to be able to have a wide-ranging expansion, even temporarily, of a rental assistance program like this. A lot of the ESG funds and CDBG funds were already in process. A lot of people publicly, a lot of local governments were already in line, making public and other outreaches for those funds. So there's a real question as to availability of any of those funds, but at least the CDC order at least expanded some authorities for that. There also at the Treasury is the coronavirus relief funds. Again, that's more for local governments, but again, that is helping to stand up some local governments to and augment some of their programs, existing programs, to provide rental assistance locally. Oftentimes, and if you look locally, you'll see a lot of states and cities, larger cities, have funded or created, or both, programs to help with rental assistance. The dollars are admittedly small, but people are doing what they can with those resources. So dealing with tenants. So occupancy of the property has for the moment been disassociated from the obligation to pay for the occupancy. The longer this sort of day of reckoning is postponed, the more the severe consequences for everybody involved. In the short term, landlords are encouraged to enter into rental repayment agreements. A couple of trade groups have put out some very good forms. We have one that we've generated. We're working with our clients. The idea of that form is to have something short, simple, couple pages. You don't want to overwhelm your staff, your resident with a lot of what ifs in the document. But what you want to have is something that's clear and crisp, making clear that the tenant recognizes they need to make that repayment, but also having a repayment plan that's based upon projected income, based on income changes, based on cost changes that they're currently experiencing, or some kind of moderate payment that can be revisited at a later date with the resident if they really don't have any answers to when they might be able to make another payment. But having that kind of a document, basically a document that renegotiates or adds to, appends to the current payment requirements during this time period, adds a lot of clarity. It also adds peace of mind for the resident, and hopefully also adds a peace of mind for the property owner as well. We are starting to hear feedback from property owners that are having to advance money, dip into reserves and whatnot in certain properties to pay for ongoing operations. One thing I try to tell people when we're talking about public policy and talking to that sphere, talking to commercial offices, is the IRS has decided that owning real estate is a passive activity. I would disagree with that characterization in many respects, because while putting up a unit is a passive activity, Depending on what your lease says, you may be paying for utilities. And smaller landlords are going out there themselves to service the unit. Otherwise, you have staff that have to show up and take care of the unit. My sink was just leaking, so we just had the super come by to fix it. You've got to pay these people, right? You have to do that. It's an active kind of circumstance. So basically, the idea is that there needs to be some sensitivity, and we are starting to see that the impact as people are landlords are having to deal with the lack of revenue from the operations. It's not just a monetary point. I try to relate to people. We lawyers have a term, specific performance. It is the owner still has to perform, provide specific performance, providing the housing. So there needs to be some kind of a plan as to when that account might get trued up. And unfortunately, without further government intervention, a lot of that is between the tenant and the landlord. So here's hoping that we're going to be getting some further government intervention in a helpful manner. In the short term, again, landlords should encourage their tenants to enter into rent repayment agreements, monitor state, local moratoria, think twice before pursuing an eviction for non-payment. Eviction because somebody's damaging the unit, menacing another resident, any kinds of other things. That's, again, you still want to check because there are certain pronouncements that might make that difficult. But you certainly, before you pursue eviction for non-payment, want to due diligence to assess if the tenant is likely to qualify for this CDC declaration, and be prepared to suspend the eviction if the tenant delivers that declaration, and not accidentally walk into civil or criminal penalties, either as a landlord pursuing the operations of their property, or as a resident filling out one of these declarations. So with that, let's see. Okay, we're at the additional resources page. Let's see, Harry, are there any other questions? I answered a couple online here. If you there were that you want to speak to.
Richard, hey Richard, one of the questions I think this is a good one. Does a landlord under the CDC order have any formal or affirmative obligation to notify the tenants in advance that they can file a declaration? And based on my review of the CDC order, I would say no. I don't think that the CDC order imposes any affirmative obligation on the landlord. The duty, as we've discussed, the way this works seems to be that the tenant invokes the protections by delivering a declaration, but that the landlord himself doesn't have that obligation. Having said that, the Office of Public Leading and Housing had a webinar a couple of weeks ago where they said that in their view, PHAs should be notifying tenants, voucher holders, and public housing tenants about their rights to file a declaration. The specific grounds for that were not stated in the PIH webinar. So HUD at least seems to have some views on the subject, at least when it comes to public agencies. But I think that may go more to the question of what the agency's obligations are as a public service to provide that kind of information. I'll also say that during that webinar, PIH basically said, this is not our moratorium. We don't know a whole lot about it, and we expect that the CDC is going to be issuing further clarifications or guidance as the weeks progress. So it'll be really interesting to see if CDC issues guidance, how the Surgeon General becomes an expert on housing policy. That's for the future to tell us, I guess.
And while you're talking and answering the question, somebody texted here that the Texas Supreme Court is requiring proactive notification of the CDC declaration. that just is a really good example of how this is very much a moving subject. Obviously, it's vitally important. Everyone on this call understands that where people live, and it's also how to maintain and keep in good condition where people live. So you're going to continue having a lot of attention put on this situation. I will just sort of repeat one thing that I just touched on very early. Going back to the states and localities have quote unquote police power, whereas arguably the federal government does not. Not police as in Holt, who goes there police, but police as in the ability to legislate for the general welfare. There's legal scholars cite the different parts of the Constitution, 10th Amendment, and certain other provisions, but it has been well established. There's a series of cases back in the 1930s, from roughly 1932 to 1935, during the Great Depression, with foreclosure and eviction moratoria that were instituted by different states, many states at that time, that were upheld, and at the same time, certain portions of the New Deal program doing some of the similar activity, buying land for the purpose of providing additional housing, that sort of thing, were held unconstitutional. So it's not an entirely neat legal fit, but it does provide a lot of historical context that these have been the issue of protection of residents. Has been very much a state and local issue, one that allows itself perhaps to be more narrowly tailored at that level. And so we're going to continue to see that kind of legislation, that kind of interest and focus, because even if it's not the federal government's role, it certainly is a role for other levels and under other circumstances. With that, like I said, we're at the additional resources page. We'll share this PowerPoint, and these provide, as I say, additional resources. I'm also supposed to read to you the code for CLE. That code is NP, as in Nixon Peabody, CLE, is continuing legal education, 092520. I'm going to say that again, NP CLE 092520. And you know what? I'm even going to type that in the comment box here, if it lets me. So with that, well, it's not going to let me so fast. So with that, I'm going to, wait a minute. Let's see. I'll do that. So that's also in the Q&A, and in case anyone didn't hear it. We'll follow up later and send an email to participants with the materials in the form to fill out. So look for that. With that, I want to, since we're just about at the right amount of time, about a minute over, I want to thank my colleagues Brian and Harry, and thank all of you for attending our webinar today, and hope that you found it, as our bright shiny faces, useful and productive as you work to provide housing for your residents. Thank you.